Morning. Yes.
May it please your Lordship. I beg to mention item number 43. Lordship. Lordship kindly.
43?
Yes, Lordship.
Yes.
Lordship may kindly grant 2 weeks time to file impediment petition.
In item 43. As prayed by MS
MD.
M. Day, Learned Counsel for the petitioner.
Yes, sir.
Petitioner lists this matter after 2 weeks to enable the petitioner to file necessary impleading application.
May it please your Lordship. I beg to mention item number 16,
1.
1/6 of the daily list, Lordship.
Yes. What do you want?
Finally, the matter may be adjourned for today. Engaged counsel is not out of session, Lordship.
You are?
B. Deka on behalf of
Mr.
Mr.
B.
A. Ganguly.
Dekar, Learned Counsel for the petitioner, submits that the arguing counsel, Mr.
A. Ganguly.
A. Ganguly, is not in station and as such prays for accommodation for the day. Stop. Prayer allowed. Have you taken consent from the other side? Prayer not opposed. Don't say prayer allowed. Prayer is not opposed by the other side. Prayer allowed. List after 1 week on a date to be fixed by the registry.
May it please, Lordship. I beg to mention item number 33, madam.
Item number?
33, madam.
Yes.
Here I want to file my reply, madam. I need 3 weeks time, madam.
Have you? You are for the petitioner.
Petitioner, madam. I have taken consent from the other side, madam.
In item number 33, Mr. N.J. Khatania, Learned Counsel for the petitioner, takes 3 weeks time for filing necessary reply. Prayer allowed. List after 3 weeks on a date to be fixed by the registry.
Oblige, Lordship.
May it please your Lordship. I beg to mention item number 42.
Yes. This is the order matter. You wait for your turn. Next. Don't mention order matters, please.
May it please your Lordship. With the consent of the other side, I beg to mention item number 10 of the daily list. Your Lordship, in this matter, Mr. S. Count appears he is out of station.
Item number 10.
Yes, Your Lord.
What is your prayer?
Mr. S. Count is out of station, Your Lord.
Your name?
S. Sharma.
MS S. Sharma, Learned Counsel for the petitioner, submits that the arguing counsel, Mr. S. Count, is out of station and accordingly seeks accommodation. Stop. Prayer not opposed. List on
Next week, Your Lord.
list on next week on a date to be fixed by the registry.
There's an interim, Your Lord.
Interim, if any, shall continue till then.
May it please your Lordship. Lordship, I'd like to mention item number 53 to 59, Lordship.
53.
Hearing matter. The counsel in this matter is out of station.
53.
Yes, Lordship.
This is a connected matter.
Yes.
So item 53 to 59.
Yes.
MS
And Begum.
and
Begum.
MS and Medhi.
Begum.
Begum. MNS Begum, Learned Counsel for the petitioner, submits that the arguing counsel
Is out of station.
is out of station and accordingly seeks accommodation. Prayer not opposed by the other side. List after
3 weeks.
3 weeks on a date to be fixed by the registry.
Much of.
I beg to mention item number 11. In this case, madam, I have to take instruction from my client so far his interest is concerned because this matter relates to 27, madam. 17. Again, madam, he is also running a madam outlet, madam.
Your name is Mr. M.K. Sharma?
Madam.
Mr. M.K. Sharma, Learned Counsel for the petitioner, submits that since the matter pertains to 2017,
Madam.
he seeks some time to get in touch to obtain instructions from his client in the matter. Stop. Prayer allowed. List after
Any date after
Moitri, 2 weeks after date. List on so and so date. Next.
oblige.
Yes.
Item 42 of today's list, my lord, that may not be taken up.
By me.
I have not informed our
Item
petitioner.
number 40?
42.
42. Actually, 42, not by me. Yes, call the list. Yes, what is this?
Matter regarding Lordship, non-payment of
Transportation
dues.
charges.
Yes, Lordship.
Yes, Mr. Talukdar.
We have filed our affidavit, my lord.
You have filed your
Even counter.
respondent number 3.
Respondent number 3. Yes.
Do you want to file a reply?
No, Lordship. In the similar matters, Lordship, given
Yes, please, Rupa. Give me the order. This is transportation charges, no?
Yes, Lordship.
Admit it?
Well, not, we have said in our affidavit that we have paid some part of it, my lord. Lordship may kindly have a look
Paragraph?
at paragraph 7 of our affidavit. That with regard to the statements made in paragraph 7 of the writ petition, this document begs to state that government has fixed maximum limit of rupees 100 per quintal rice by government guideline and action calendar implementation of Mukhyamantri Aina Suraksa 2010 for transportation of incidental charge. But again, the government has refixed the rate of transportation cost of so-and-so by letter number so-and-so, dated so-and-so, at rupees 11 at the distance of 0 to 5 kilometer, and 17 for 6 to 10 kilometer, and 20 for 11 to 20 kilometer, 22 for 21 to 30 kilometer, and 31 to so-and-so from 50 to 50 kilometer, and 37 for, and above for 51 kilometer per quintal. In
So
plain
a sum of 46,099 has already been received by the petitioner.
yes,
Right?
yes, ma'am.
Anything due?
That they will, my lord,
I have no instruction about this thing, Lordship.
So you take the instruction then.
Okay, Lordship.
That is why I asked if you want to file a reply.
Kindly.
It appears from the affidavit filed by the respondent number 3 that a sum of rupees 46,099.00 as transportation charges have transportation charges of MMASY rice for the period October 2010 to March 2011 has already been paid to the petitioner. Stop. Accordingly, MS
MD.
N days 2 weeks time to obtain instruction in this regard. Stop. List this matter after 2 weeks on a date to be fixed by the registry. Rupa, return this. What? Yes.
May it please your Lordship. Lordship, this matter is pertaining to the Central Excise Refund, Lordship.
Senvet.
Senvet, Lordship. So what happened, the first round of litigation we won, that 100% exemption was their first round of litigation we won. Then they filed a writ appeal. That was enough, that decided in our favor. Then we went to Supreme Court. And Supreme Court ultimately decided the matter in 2020 that those two amended notifications which had reduced the benefit of 100.
That's Dharampal Satyapal's case? No.
Yes. All the whole series, Kamakhya Cosmetics, Dharampal Satyapal and all the matters. So that is the position as on today. In this case, Lordship, that is involving that, but actually we have not challenged the notification in this. In this meantime, in 2017, the department against these petitioners had ordered demand notice, which we say that it is illegal at that time.
So you are challenging the demand notice?
Demand notice which they have while in violation of that, because DB order was there, matter was pending before the Supreme Court. In between, they could not have asked for the amount, for reversal of the amount as well as the interest to be paid on it. So we challenged that matter. So this was kept in stay. So now, Lordship, in view of the review judgment, if
Who is
Lordship,
appearing for the other side?
I am not in the case, my lord, if your lordship permits me, but
Then let me admit this and post it for hearing.
yes, Lordship, it will need a detailed hearing. It will need a
Absolutely.
detailed
he is in
hearing.
another court.
Very well, we are admitting this.
Lord,
Heard MS MS ML Gope, Learned Counsel for the petitioner. Stop. None appears for GST department. Stop. upon here, this case needs to be, no, you write like this. Petitioner has made out a case for hearing. Stop. Admit. List on. Give me a date. When do you want for hearing?
May, in the month of May, Lordship.
Yes, month of May. I thought
May
date is here.
14th,
14 May.
14th or 15th is Tuesday.
Poetry. 15th May.
It's a Wednesday. 14th is Tuesday.
16th.
16th.
List on 16/5 so and so for hearing. Just before that, you say no formal notice as parties are represented. This is item number 229.
Yes. Item number 34.
Also item number 34,
34.
and also 34.
Lordship, there is an interim that I
Interim, if any, shall continue till then.
much of that.
Yes, demarcation of land. On the last occasion also there was nobody represented for the petitioner. This is the non-entered appearance on behalf of the petitioner. Stop. Mr. So-and-so learned additional, your additional senior government, you're appearing as additional senior government advocate assisted by so-and-so, please give the name, is present for the rest of the respondent. Stop. It appears that on the last occasion, 21/1/2021, also none entered appearance on behalf of the petitioner. Stop. Considering that consequently the petitioner is being unrepresented, this writ petition stands dismissed for default. Disposed of. None appears for the petitioner. List next speaker, date of the detail.
Next week.
Yes, Mr. Khatoniar.
Yes, ma'am. Here, my lord, I am praying for little accommodation for today, my lord.
Accommodation for today.
Today, my lord.
Item 14.
14, my lord.
The whole matter,
It's an old matter, my lord. My lord, next week, my lord.
as prayed for by Mr. N.J. Khatoniar, list this matter next week, date of the detail. 3/5/2024.
Yes, ma'am. Obliged, lord.
May I please, Your Lord?
Yes, what is this? Transport validity?
Yes, my lord. My lord, date has been, my lord, given, my lord, in an endorsement by the district transport officer, my lord, ignoring the renewal of my driving license, my lord. So it has been stated in the endorsement that it is till 2013.
Affidavits have already been filed, right?
My lord,
Pleadings are completed.
Lordship.
Yes, what has been wrongly noted?
In fact, my lord, your lordship will kindly come to this endorsement at page 39. And
Page
this is
39.
transport validity is shown as, my lord, at serial number 5, 17/11/2013.
One second. Yes, page 39.
Page 39, my lord, at serial number 5, my
The
lord,
transport validity has been wrongly shown.
as 17/11/2013.
It should be recorded as
It should be, my lord, in fact, my lord, 19/02/2017.
19
19/02/2017.
2017.
17, my lord.
So after this, you filed an application for correction.
In fact, my lord, no correction for any, my lord. I verbally approached the authority, and my lord, when that was, my lord, under consideration, my lord, the very DTO concerned, my lord, he got transferred, my lord. So in that view of the matter, my lord, the authority, my lord, officials, my lord, they reluctant to just, my lord, correct this.
So
my lord.
did you file any application?
My lord, in fact, there was no application as my instruction, my lord.
No, but without application, how come you have straight away come to the court?
In fact, my lord, because of this, my lord, this endorsement,
Correct. There has been a wrong endorsement, but did you make any representation or not?
In fact, my lord, there was no representation, but my
Then-
lord, I approached verbally the authority, my lord. That is, I have stated in my affidavit, my lord. So because of the, my lord, these codes, my lord,
Mr. Taluk, who's appearing for transport? You are appearing? So, I think if he can file a representation and then...
That is another aspect, my lord. In the current status, my lord, the petitioner has produced a license in which the endorsement of phone quality exists. So there was a CID inquiry initiated. So, my lord, the matter was fixed for the status of the CID report.
Have you produced it?
My lord, the
Mr. Talukdar, you have the CID report? You've got it? What does it say?
Some report, Lordship, I could not.
You want to place it by way of an affidavit?
Yes, Lordship.
Mr. P. Talukdar, Learned Additional Senior Government Advocate, assisted by so-and-so, submits that he has received you received the CID inquiry report and seeks 1 week time to place the same by way of an affidavit. Stop. Prayer not opposed. List this matter after 1 week. Give me a date first week. 2-5. All right.
May I please, Your Lordship, may I kindly, there is the last order dated 1/4/24.
Yes, PNRD. You want more time?
Lordship.
See, this is a 2018 matter on the. I understand now the election time and people are
Lordship, we
busy.
have received a copy on 5/4/24. Earlier, our name was not shown in the call.
All right, we'll give you time. How much time do you want?
Let's kindly choose.
How much time? 30 days. Yeah, we are not going to give you 1 month time for a 2018 matter. Be
two
reasonable with your
Lordship, 2 weeks time.
Huh?
2 weeks time may be done.
MSN Bora Learned Standing Council PNRD produces a communication dated 18/4/2023 issued by the Chief Executive Officer Jila Parishad Hailakandi, whereby 30 days time has been requested for submission of the parawise comments in view of the fact that all the concerned functionaries are badly engaged in parliamentary election 2024 duty. Stop. Then next para. Considering the matter pertaining to 2018, this court grants 2 weeks time as a last chance to file the necessary affidavit in opposition in the matter. Stop. List after 2 weeks date Didiba.
May I please, your Lordship? Lordship, our name may be shown in the first time.
Name of the standing council PNRD be reflected in the cause list. Registry. Registry. All right.
Of less.
18
Okay, may I pray for accommodation for today, Your Lord?
Yes, Mr. Das.
In this petitions, Lord, we have challenged in both the petitions. We have challenged in one. We have challenged the order of the DC, whereby committee has been given the charge of managing the
18 and 19.
Yes, Lord.
Mr. Das, Mr. D. Das. DJ Das, right? Mr. DJ Das, Learned Counsel for the petitioner, seeks accommodation in the matter
For today, Your Lord.
for the day. The prayer is not opposed. List this matter next week on a date to be fixed by the registry.
Lordship, 20 is the contempt matter. Your Lordship. 20 is the contempt matter.
It's connected.
Despite of the
All right.
May
1920.
I please, Your Lordship? In 20th matter, my Lord, I am appearing for a respondent number 2. The order has already been complied, and also the
You submit on that day next week.
order
Next
that
order
has been
complied.
submitted, Lordship.
Is order
Lordship, I have received the order, but Lordship, in for records, Lordship, it has been stayed, but practically, Lordship, that managing committee is still functioning, Your Lordship.
Yeah, one second. In item 20, you write heard Mr. DJ Das, Learned Counsel for the petitioner. Stop. Also heard
A Deka.
Mr. A. Deka, Learned Counsel for
The
respondent
respondent
number
number 2.
2. Stop. Mr. A. Deka, Learned Counsel for respondent number 2 submits that the order has already been complied.
My lord, already the
So
DC,
complied.
DC has
complied.
already been
Stop.
transferred. Respondent number 2 has already been transferred.
And the respondent number 2 has also in the meantime been transferred. Stop. Mr. DJ Das, Learned Counsel, 1 week time for obtaining instruction in this regard. Stop. Okay.
Much of it.
List after one, list along with or?
Lordship, let it be tagged, Your Lordship.
Okay. So same date, huh? 18, 19, 26. All right. Next.
Much obliged.
Problem.
Lordship, in this case, recently respondent number 1 and 4 have filed their affidavit in opposition.
You want to file reply?
Yeah.
Your name?
S. Das Gupta.
MS S. Das Gupta, Learned Counsel appearing for the petitioner submits that respondent number
1 and 4.
1 and 4 has filed their affidavit in opposition in the matter and accordingly seeks time for filing necessary reply against the said affidavit. Stop. Prayer allowed. List after
2 weeks.
2 weeks on a date to be fixed by the registry.
Much obliged.
Yes, TDS amount.
Lordship, the respondent
Our
number
department
1
has
has
already
already
been
filed
paid.
an affidavit, Lordship. I have not found the affidavit on record, Lordship.
Have
Respondent
you
number,
received or not?
I have received on 15/3, Lordship.
The affidavit is on record.
Paragraph number 7, probably, Your Lordship. There affidavit filed by respondent number 1, Lordship.
He's right. The affidavit. Oh no. Affidavit. There is one affidavit by R3.
Lordship.
That is the affidavit.
No. Affidavit filed by respondent number 1, Lordship.
It is submitted at the bar that the respondent number 1 has filed a affidavit in opposition in the matter. Stop. However, the same is not on record. Registry to verify and place the same on record.
Lordship, a date may kindly be fixed.
List on
1st of May.
list on first week of May on a date to be fixed by the registry. Next.
Interim order passed earlier, May 4th.
Interim, if any, shall continue till then.
Obliged.
Why are you submitting in piecemeal? Say it one go. Yes, next. Yes.
In this case, the pleadings are complete. Lordship may take up for the disposal also subject to day agreement.
Disposal today will be difficult, Mr. Saikya. We'll admit and post it next week if you want for hearing.
Yes, that can.
Is that okay? Heard Mr. PJ Soikia, Learned Senior Counsel for the petitioner, assisted by
R.S. Mishra.
You got the name? R.S. Mishra. On behalf of the petitioner. Stop. None appears for the respondent. You are there. MS S. Sharma, Learned Counsel. You are appearing as Junior Government Advocate. Yes. Learned Junior Government Advocate, Assam, is appears on behalf of 1 to 6. Huh?
And also 8.
And 8. Then you say pleadings are completed. Petitioner has made a case for hearing, has prima facie made out a case for hearing. Admit, no formal notice, as parties are represented. List on next week date, on so and so date for hearing.
All right.
In these matters, Pollution Control Board actually 2019 issued some orders, some closure and some fine. Then Pollution Control Board subsequently, in 2022, issued an order regarding withdrawal of the closure notice and withdrawal of the fine.
So this matter is, anything is surviving in
No,
the matter?
now the Pollution Control Board has to produce a list. List is not, it will also see.
Who is appearing for
There
the
are two.
Pollution Control Board? Anybody appearing for the Pollution Control Board? Yes.
He can produce the list, my lord, so that it can be closed, my lord.
Do you have the list?
I have got the list and I have provided to the petitioner also a long time back.
No,
So
that,
it was this list consists of
This has been published long
Mrs.
time back.
Sahewala, have you received
No,
the
no,
list?
no. I have
Then you
provided.
please, Mr. Borwa, let's not waste time on that. You give the list.
No,
Mr. Borwa, you give it again. Let you
no,
examine
I'm
Mr.
sorry.
Sahewala.
I'm sorry. I have mistaken. I have provided the notification which consists of the number of units which has
So
been.
now you get the list.
But
and
unfortunately, I have tried my best. So in this notification, it has been mentioned that in the website it is available, but this website is not to be found because the rehauling has been taken place. So if at all the petitioner can write an official letter, whether their name has been included in amongst these which has been included in this notification.
why should they do all this? You produce it. You are representing the department.
Yes, I
You
have.
get hold of that list
Last-
and you produce it on the
last
next
time
day.
also, yes.
No. Mr. S. Borwa, Learned Standing Council, Pollution Control Department, PCBA.
Yes.
PCBA shall produce the list.
List, my lord, as per the order dated 10th March 2020.
List as per order dated 10/3/2022 on the next date. Stop. List on, you want a date?
Any date, my lord, I think.
2 weeks?
Lordship, can it be in this language that whether the petitioners' companies or industries are included from amongst which has been waived? Yes, that would be more precise.
Then you cancel that and you say, Mr. S. Borwa, Learned Standing Council, PCBA shall obtain instruction as whether the
Petitioners' unit or
falls
in the units which has been waived of the
falls
environment
in the
compensation.
unit which has been
Waived of the environment.
waived of the
Environment compensation.
environment
Compensation.
in terms of public notice dated 10/3/2022. So,
Yes.
list where? Tell me a date.
After a week.
After a week, date did you list on so and so. Mrs. Avila, please take this back. Rupa.
Interim order may continue.
Interim, if any, shall continue till then. Yes, 27, 28. None appears for the petitioner when the matter is called. List after 2 weeks on a date to be fixed by the registry. None appears for the petitioner when the matter is called. List after 2 weeks on a date to be fixed by the registry. The old matters, it's very difficult to dismiss them. It will take me a minute to dismiss it. None appears for the petitioner when the matter is called. List after 2 weeks on a date to be fixed by the registry.
In this matter, affidavit in opposition has not been filed by the respondent.
Sorry?
Affidavit in opposition has not been filed yet by the respondent.
Who is appearing for the other side? Mr. Kayal?
Yes, Your Lord.
GST? He's not there. When petitioner are there, respondents are not there. Call for Mr. Kayal. Wait for some time. Next. Yes, Mr. Das.
My lord.
Transport subsidy.
Yes, my lord. Transport subsidy, my lord, for the period 1/1/2008
Lordship, what affidavit has been filed yesterday, so it hasn't come on record. So it
Additional
may-
affidavit.
No, affidavit in opposition.
You have filed it?
Yes, yesterday.
Mr. Kalita, Mr. Kalita, Learned Council for
Industries and Commerce Department.
For Industries and Commerce Department submits that the affidavit in opposition has been filed yesterday. Give the date, okay? Stop. However, the same is not on record. Registry to verify and place the same on record. List on, Mr. Kalita.
After 2 weeks.
Next week, my lord, because this is
After 1 week on a date to be fixed by the registry.
or lordship may fix a date
It's
because
all right. The registry will fix a date.
My problem.
Gope, I thought you had said this is the
Yes.
part of that series.
No. It's little different.
This is
Lordship,
different?
because- Yes, we can actually this matter can
34
be
is not part of that 229. Yes.
this matter can be disposed of in this line. Actually, I'll place this order before your lordship, and lordship may take up one
Who
order
is
which
appearing for the other side?
Mr. Kaya.
Then you wait for some time.
Yes, I may make.
You, in the meantime, you can ask one of your juniors also to ask him to be in court. You can inform. Yeah. All right, let him be there then, or you want it on Monday?
Monday.
You wait, let him come. None appears for the petitioner on call. It appears from the order dated 1/12/2023 that the petitioner was that none appeared for the petitioner on that date also. Stop. In view of the fact that there has been non-representation on behalf of the petitioner consecutively, comma, this petition stands closed on being non-prosecuted default, closed for default. Disposed of, huh? 35. Yes, Mr. Das?
I think it's a construction work, my lord, where we completed 83%. And payments not made. Some 2 crores are.
Yes, why payments are not being released?
2 crores has not been paid.
Who is appearing for the other side?
I think PWD is appearing. They are not here, I think.
PWD, anybody is there? Do you want another date, or we can keep it for
another date?
Another date. Third, Mr. Didas Leonard, senior advocate, assisted by
S. Sharma.
MS S. Sharma. Stop. None appears for the PWD department when matter was called. Stop. It is submitted by to say that list after. You want a date?
Whatever is convenient.
List after 2 weeks.
Okay,
list after 2 weeks. 6/5.
6/5 is okay. No, okay.
6/5 is convenient?
Yes.
Next. Yes, Mr. Roy.
This is down payment of compensation.
Who is going to pay? Yes, Mr. Kaur, why payment has been not released?
My lord, this will require some length of hearing. My lord, the pleadings are complete.
No, but give me the reason why payments have not been released.
Yes, because my lord, we have filed an affidavit where we have taken a stand, my lord, that the issue, my lord, date back, my lord, to a prolonged period. Now, my lord, it is not feasible for the government within the parameters of law to open up the compensation cases.
Is there some guidelines which prohibit?
Page 63 may be seen, man.
Page 63.
63. The government has taken a decision
not to allow reopening of the compensation cases, which relates to 1960. These are what compensation? Land
compensation.
The part and parcels of the land, my lord, belonging to the petitioner.
Mr. Roy, have you challenged this?
Yes, I asked for set aside, and lordship.
This is under challenge in this petition.
Yes. And lordship see that unless there is proper justification. So if I justified, I have already filed my affidavit in reply also, I justified, and they took, my lord, 40 years, now it is 70 years, my lord, the compensation not paid.
When was your land acquired?
58-59, my lord.
58-59.
There is an order of the district judge.
And when did you first apply for compensation?
I applied, my lord, in 69 itself, my lord. 69. Your lordship, prior to 69, your lordship, see the page 21 is the order of the district judge.
So within 10 years you had applied?
Yes. No, I applied immediately, my lord.
Immediately.
58-59, and probably in 60 I applied for the compensation. And 69, the judgment of the district judge is there, man.
69 is the judgment.
69.
That judgment is under challenge.
That is already, they went up to Supreme Court, my lord. That is, the SLP got dismissed, my lord, after 20 years.
Okay.
So then, my lord, there was a committee formed, my lord. The committee has assessed the compensation. Now the compensation I have annexed, my lord. Lordship will see page 108 of the affidavit in reply, 108. Annexure 1.
Yes.
The compensation has been assessed, my lord, to 19,68,059.92 paisa.
Yes.
So this amount I have to get it with interest, my lord.
You are all right with this amount.
Yes.
And but why is this not given to you then?
This
order is of 60?
58, 59,
the signature
69, my lord.
69.
69.
69 or 65? 69.
69, my lord. The judgment was delivered on 13/3/69.
So
page
after
21.
this, what happened?
Then, my lord, Lordship may see, my lord, page 44, the High Court order, my lord. Page 44.
44A or 44?
44, my lord, Annexure 3.
Yes, yes.
High Court also upheld that order, my lord. Operative portion is at page 54. However, the draft statement will have to be revised in view of the findings of the first 2 points. The respondent may given an opportunity to adduce evidence to prove that the amount of the alleged income tax includes any super tax if they can have that such super tax will not be deducted.
Then
they went to Supreme Court, my lord. Supreme Court took 20 years to dispose of my petition in page 55, my lord.
55?
Supreme Court dismissed it, my lord, their SLP.
Yes.
They have challenged it, Admiral. Then the committee was formed, page 56.
Page?
56, my lord.
Yes.
The committee will review the case carefully and if necessary call for records and hear all concerns. The committee will place its finding before the Deputy Commissioner Dubri, who, if satisfied, will send the cases to state government with the recommendation, and under his signature, the committee will complete the entire exercise in 6 months. So, my 9 cases also sent to the committee, and committee recommended for compensation matter. Lordship may see page 59 is the operative portion, my lord. Last para, my lord.
So this was after the Supreme Court order.
After the Supreme Court.
Supreme Court.
Supreme Court, my lord, in 1996 delivered the judgment.
96.
96, my lord. 23/1/96.
Why from 96? Government took so much time.
18 years, my
18
lord.
years.
18 years.
Mr. Borpujari, you can't now say that you cannot reopen. There has been substantial time spent by your office also.
No, that is
from 96 to 2014.
Because, my lord, here, my lord,
and the person got died after.
Because, my lord, the authorities are required to carry out an exercise on facts, my lord.
You see, that notification which you have, which Mr. Roy have said, is also saying if proper justification. So there is justification.
Otherwise, my lord, there is a, my lord, if my lord may be pleased to come to page 17 of the writ petition.
1 second. Mr. Roy, anything else you want to
Yes,
show?
my lord. Then, Lordship, the committee recommended, my lord.
Yes.
I have shown the page 59, my lord, operative portion, my lord. In the premises of the legal position
59.
We may recommend to the government for review of the cases as per Annexure 1. So my cases were there, page 60, my lord.
59 is the operating part of the recommendation
Yes.
on verification of the order sheet.
Of review committee, my lord.
No, at 56, this is the Deputy Secretary's order whereby
yes,
it says will review.
Review, my lord.
And then the committee had taken up for review.
Recommended for review, my lord.
And
Then
ultimately,
page 60, my lordship may see.
Ultimately, what is the
Page 60, my lord, my cases are from serial number 9 to 16, my lord.
Okay.
Then, my lord.
So they have reviewed.
Recommended.
And they have recommended.
Then the page 60, my lord, impeachment order come, my lord. That
what is this, Mr. Borpujari? Committee has already recommended.
The committee has recommended.
And unless there is proper justification is already there. Supreme Court order is of 96. 2014.
And I have given an order also, my lord, coordinate bench, my lord. Coordinate bench order I have given, my lord, that page, my lord, 64, that is. Similar cases, my lord. Honorable Justice Ujjwal Bhaiya then passed an order, my lord, on 10/6/2019, page 68, my lord. Similar, my lord, long pending case, my lord. And it is not that they have not assessed the compensation. They have assessed the compensation I'll show to RTA order also, my lord. That page 70 may be seen.
There also the petitioner expired.
I've given a family tree, my lord, which may be seen at page 20, my lord.
One second.
This is Raja Prabhat Chandra Borwal, page 20, annexure 1, my lord. Now the petitioner is, my lord, he is a power of attorney holder.
All right, Mr. Roy, one second. Mr. Borpujari, please tell me what steps have your office taken after 96?
Yes, if my lord may be pleased.
What step they have
Yes, if my lord may be pleased to come to page 59 for a moment, my lord. I will explain the matter.
59.
59 of the writ petition, my lord.
Yes. Yes.
Page 59, my lord, paragraph number 2.
Yes.
My lord, that was the findings of the, my lord, the review committee. As per Gazette notification for acquisition of land under the Act were taken up for assessment of compensation by opening the cases mentioned in Annexure 1. On verification of the orders it maintained in those cases, it could not be ascertained whether the notice were duly served upon ex-tenure holders, and as such, due to absence of proper service of notice, the ex-tenure holder might have been barred from participating in the proceeding taken up for assessment of compensation of their land acquired under the Act. Then, my lord, paragraph 3. Consequent upon the absence of ex-tenure holder, all the cases were found proceeded ex parte, and it is revealed from the order sheet maintained in all the cases that the compensations were closed, cases were closed with nil assessment. The scheme of the Act is that the compensation shall be paid to the ex-tenure holder or to their legal heirs against the acquired land under the provisions of law. In the premises of the legal position of the cases, we may recommend. So it was a recommendation. It was not a direction per se.
No, that's right. There was a recommendation.
Recommendation for review. Now, what the government has done, that Lordship will kindly see, my lord.
Now, who will do the review?
We will do the review.
So has that review been done?
No, that review.
No, now you take a stand that no, we will not reopen.
We will not reopen. That was the stand.
Now, where I am trying to say, now your ground for not reopening is that which relates to 1960, right?
Yes.
But there has been a considerable delay otherwise.
Absolutely.
That is not for their fault.
Absolutely.
For XYZ reasons which we have already seen.
Absolutely.
Right? When it was pending for a long time, then your department took a lot of time to pass these orders.
Absolutely.
So these are otherwise justified.
No, therefore, my lord, the petitioner themselves have given a handle to this honorable court. My lord, therefore, I am trying to draw your lordship attention to page 17.
Page?
Page 17, 17. 17. That is the prayer portion. What is exactly their prayer? Page 17, 17.
Yes, yes.
When I read in the nature
to
manner,
consider the
representation. So that representation, lordship will find at page 72. Page 72 of the writ petition. Lordship may be pleased to close this writ petition, my lord, directing the respondent, the department, revenue and
70?
72. They will be satisfied if this representation is, my lord, disposed of with a speaking order. That much.
Mr. Roy, my lord, will it be, if we dispose of with the direction that we will of course record a finding that it appears that there are a justification is that.
Yes.
That much this court will record
Yes,
because it appears from record that there is a justifiable cause.
And para 3.
However, this court will not pass any positive order, but instead
let them
we will-
determine the compensation as per, my lord, annexure 1 of page 108. I have shown that.
We will only direct.
No, they will decide the compensation as
Mr.
per.
Roy, you
They have
hear the
already
court?
calculated, my lord.
You hear the court one. We will, in terms of whatever you have said here, right?
Yes.
So we will say that the representation may be considered as per the stipulations of so and so.
Right.
That much.
Right.
All right.
They will, my lord, dispose of the representation taking in view, my lord, the provisions of the 1951 Act. Because that is the Act.
Yes. And also, my lord.
All right, you mentioned that at the time of.
My lord.
Please
And in
start.
terms of the order of the district judge.
All right, you let. We will add that. First, let me just take dictate the facts. Heard Mr. J. Roy, learned senior advocate, assisted by
P. Shah.
MS
B. Shah.
B. Shah. Also heard Mr. R. Borpujari, learned standing counsel, revenue department.
For R1.
For within bracket, respondent number 1. Anybody else? No.
Yes, my colleague. He will appear for R2,
Mr. H. And Mr. H. Sharma. H. Sharma. Learned additional senior government advocate for respondent number 2. Respondent number. By the petitioners are aggrieved by the non-payment of settlement amount stroke compensation in RE of Gauripur Raj estate along with 6 permanently settled estates and 13 Lekhraj estates, estate which was acquired by the government of Assam under the Assam State Acquisition of Jamindari Act 1951 in the year 1958-59. The facts of the case is that in regard to the aforesaid acquisition, a draft statement for compensation settlement amount was prepared by the compensation officer Dhupri in connection to the aforesaid property in the year 1966.
That is 25,367.
And the same was objected to by the receivers, vide their objection dated 24/3/1966. Stop. However, the said objections raised in the draft statement were rejected by the compensation officer on 25/3/1967. Stop. Thereafter, an appeal was preferred against the aforesaid rejection before the District Judge Dhubri, I. Miscellaneous Appeal Number 28 of 1967. Stop. Next paragraph. The learned District Court, after hearing, the learned District Court, by judgment and order dated 13/3/1969, reversed the finding of the compensation officer and allowed the appeal of the receiver. So, the state government challenged the said judgment and order dated 13/3/1969 before this court by way of appeal, and the same was rejected and dismissed by this court with a judgment and order dated 16/12/1976. Stop. Pertinent to mention that the state government thereafter also approached the Honorable Supreme Court, and the Honorable Supreme Court with a judgment and order dated 23/1/96 was also pleased to dismiss the said appeal. So, next paragraph. Despite of the apex court dismissing the appeal and confirming the High Court order, confirming the order of this court, whereby the petitioner was entitled to what? Where was that amount?
Amount is, my lord, 108, my lord.
which you had just showed me,
108. My reply, affidavit in reply 108.
Yes. Sorry. Despite, can you read that? Whereby the petitioner was entitled to compensation of rupees 19,68,059.92, the same was not given to the petitioner, despite the petitioner having represented before the authority. Subsequently, the state government, with a notification dated 21/2014, ordered for constitution of verification committee of Jamindari cases pending for payment of compensation in the office of Compensation Officer Dhubri to review the pending compensation cases and put up the same before the Deputy Commissioner for forwarding the same to the state government. Stop. Next paragraph. Pertinent to mention that the case of the petitioner was also taken up for review, and on being satisfied, the same was forwarded for recommendation with a letter dated 12/11/2014. However, the same was summarily rejected to be considered by the Joint Secretary to the Government of Assam with a letter dated 1/6/2015, stating that the government has decided not to allow reopening of the compensation cases relating to 1960 unless there is proper justice. Aggrieved by the aforesaid order dated 1/6/2015, the present writ petition has been filed. Heard the council's the submissions made at the bar and have also perused the materials available on record. It appears that the petitioner's case has been. Where is that impugned order page?
Page, my lord,
that is 63. It appears that the petitioner's compensation case has been rejected merely on the ground that the same relates to 1960. Stop. By order dated 1/6/2015, issued by the Joint Secretary to the Government of Assam, Revenue (Reform) and DM Department. Stop. A copy of the said order dated 1/6/2015 is reproduced hereunder for ready reference. Page 6. Just quote it. Then you write. A perusal of the aforesaid order indicates that in the case of in the event the petitioner makes out, in the event the petitioner justifies the entitlement of compensation, the respondent authorities can reopen such cases. Stop. In the facts of the present case, as stated above, it appears that the petitioner has justified reopening of the compensation case. Stop. Pertinent to mention that the petitioner has also filed a representation before the Commissioner and Secretary to the Government of Assam, Revenue Disaster Management Department, VD letter dated 28/2/2022, which was not attended to. Stop. In view of the consensus between the learned counsels appearing for the petitioner and the respondent to the effect that this writ petition can be disposed of with a direction for considering the said representation, comma, this court for the ends of justice disposes of the instant writ petition with a direction to the respondent, particularly respondent number?
It will be respondent number 1.
Respondent number 1.
Lordship will kindly direct, my lord, the principal secretary.
The principal secretary
to the government of Assam.
To the government of Assam.
Revenue and Disaster Management Department.
Revenue and Disaster Management. To consider the representation of the petitioner dated 28/2/2022 as per the stipulations of Disaster Management and Revenue Reforms Department order dated 21/2014 on its merit and in accordance with law within a period of
1 month.
1 month from the date of receipt of the certified copy of this order. Stop.
Well, can it be 2 months, my lord? Well, because now the elections are in 2 months.
2 months.
All the officers.
All right.
My lordship will record that already 55 years has gone, my lord. They should not take any further.
Needless to clarify that since the compensation has been denied to the petitioner since 1969,
55 years,
the respondent authorities would positively complete the exercise within the time frame provided by this court. Stop. With the aforesaid observation and direction, this writ petition stands disposed of.
My lord, I maybe get liberty to approach again if they don't pay compensation. My lord.
That you always have, Mr. Roy.
My lord, one submission, my lord. My lord, along with my lord's certified copy of order, my lord.
I have given.
I will submit.
No, my lord, let the petitioners also furnish a copy of the writ petition, my lord. Along with
let a copy of the writ petition along with the certified copy of this court's order be submitted by the petitioner to the concerned respondent authority.
Only thing, my lord, imprisoned order should not affect me, my lord, because the imprisoned order should not affect me, my lord, because there is not to reopen the case.
I have already said that you have a justifiable case.
Oh, my lord, deeply obliged.
I will edit it, Mr. Roy.
Lordship, in terms of notification, DC has surveyed and accordingly, in terms of Annexure 8, DC has already admitted we are entitled for compensation. So
yes, Ms. Borman, are you appearing?
38. Okay. Lordship, kindly give direction to the finance to finance.
Is anybody appearing for finance? Mr. Borpujari? What is your stand, Ms. Borman?
That due to budgetary provision,
this is payment of financial assistance.
Yes,
what assistance for?
They are erosion affected.
They are what, Ms. Borman?
Erosion affected.
Erosion affected.
Here, my lord, an affidavit from the revenue department will be required.
Who is appearing for you? It appears that a respondent number 5 has filed its affidavit in opposition. Stop. Mr. A. Borwa, A. Bhattacharjee, Learned Standing Counsel, Revenue, seeks 2 weeks' time for filing their affidavit in opposition. Prayer is not opposed. List after 2 weeks on a date to be fixed by the registry. Mr. Borpujari, you also file your affidavit if required?
Here, finance, my lord, has nothing to do with
it.
The entitlement will be decided by the department.
Okay, let that affidavit come.
Yes, my lord. I am so obliged.
Release from custody.
Lordship, the petitioner put to silence, you Lordship, the detention order dated 13th.
Have you filed your affidavit in reply? On the last occasion, you had not time for filing affidavit in reply. Have you filed?
I have filed.
I don't think it is on record.
But I filed the affidavit in reply, you Lordship. On the affidavit, you Lordship.
It has not come on record. When did you file?
Lordship.
Mr. A. Diwan, Learned Counsel for the petitioner, submits that Learned Counsel for the petitioner submits that he has filed the affidavit in reply on
Affidavit in reply filed by the deponent, Your Lordship, on 23/2/2024, Your Lordship.
on
23/2/2024.
23/2/2024, comma. However, the same is not on record. Stop. Let the registry verify and place the same on record. List
Very short date mechanism because
list on next week and on any date picked by the registry. List next week on any date picked by the registry. All right. Next.
Lordship, date mechanism.
Next week. Yes, Mr. Kayal.
In this case, Lordship, the budgetary scheme promulgated by the central government was challenged. The budgetary scheme on 5/10/2017, central government after GST promulgated the budgetary scheme that was challenged before the different high courts. Ultimately, Supreme Court in 2023 SCC page 386 upheld the scheme board. However, some direction was given to the petitioner to make representation before the GST Council. That was the
representation before the GST.
Yes, sir.
That was not done.
Now, Lordship, give them direction, they can avail this. But the scheme was upheld by the Honorable Supreme Court.
No, otherwise, in this case, what has been challenged? The
They have challenged the budgetary scheme.
They have challenged the circulars, right?
Yes, sir.
And these have been, this similar challenge was made before the Apex Court.
Yes, sir.
And though in those cases, the Apex Court have upheld these circulars.
Yes, lots.
So now, in view of the order of the Supreme Court, where is that order?
Lordship,
this one?
2023.
VVEF Limited?
No. This is another.
Do you have the order?
Lordship, that is the...
You can just give me the date.
2023, 1 SCC. 23.
20?
Yes, 2023.
203?
Volume 1. SCC page
Can you
3.
just, I'm getting confused. You're giving me the citation?
Citation, Lord.
Yes, please say
2023.
Yes.
1 SCC.
Yes.
Page 386.
386.
Date of judgment is 17/10/2022.
17/10/2022.
2022. The name of the party is Hero Motor Corp Limited versus Union of India.
Can you go slow?
Hero Motor Corp.
HERO.
HERO.
Motors.
MOTOR.
MOTOR.
CORP.
MOTOR.
CORP.
CORP. Motor Corp.
Limited versus Union of India.
Limited. And in that decision, what is the operating part?
Lordship, the scheme has been upheld, and in paragraph 80, married Lordship.
Paragraph 18?
80. We therefore permit the appellant to make representation to the respective state government as well as to the GST Council. We also request the state government and GST Council to consider such representation.
All right. I might borrow your
Lordship.
iPad for a minute.
Lordship.
All right. You write. Heard Mr.
PK Bora.
PK Bora, Learned Counsel for the petitioner. Stop. Also heard Mr. SC Kyle, Learned Standing Counsel, GST, within bracket respondent 5 to 7. Stop. Anyone for SDI?
Mr. RK Chaudhary is there.
Okay. Mr. RK Dev Chaudhary, Assistant SDI for respondent number 1 to 4.
No.
The present writ petition, the petitioner is challenging notification number F number 10 within bracket 1 2017 dash DBA dash Roman 2 NER dated 5/10/2017 and the consequential circulars dated 27/11/17, 30/11/17 and 10/1/19 issued by the Central Board of Excise and Customs, Ministry of Finance, Department of Revenue. Stop. It is submitted at bar that similar challenge has been made before the Honorable Apex Court, and the Honorable Apex Court by judgment on order dated 17/10/2022 reported in 2023 Volume 1 SSC 386 in the case of Hero Motors Corp Limited versus UOI upheld the said circular. Now, paragraph, relevant paragraph to quote would be paragraph 80.
Lordship 80.
Paragraph 80 of the aforesaid judgment is quoted hereunder for ready reference. 80 to quote for it. In view, then you write, in view of the aforesaid judgment and order of the apex court, comma, this court considers this court considers fit to dispose of the writ petition with the direction that the petitioner shall make representation before the GST Council and upon receipt of the said representation, comma, the GST Council shall consider the same in accordance with law. Within a period of 2 months. Within a period of 2 months from the date of receipt of the certified copy of this order. So, you want to say something? No. So, in with the aforesaid observation direction, the writ petition then disposed. Point 3 is to the annihilate.
Objection. In this case, probably the VBF judgment will be applicable. VBF judgment.
Yes.
Lordship, in this case, what happened?
Is this judgment applicable?
Yes, Lordship. After this judgment, the liberty was granted them to file an application taking the special writ. In writ petition, in paragraph 7, page 9.
Yes.
May I read, Lord?
Yes.
That the petitioner most respectfully begs to state that the petitioner immediately on receipt of the notice, after reading the judgment, had taken a legal opinion and came to know that the notification dated 27/3/2008 and 10/6/2008 have been held to be clarificatory and have revived. The petitioner immediately being eligible for valuation addition filed the application for special rate value addition before the Commissioner Guwahati at respondent number 2, which was contemplated as per judgment of the Honorable Supreme Court dated 22/4/2020. Further, the same were within the reasonable time after the passing of the judgment of the aforesaid. What may now come to Annexure 7, Lordship.
Page
173.
Yes.
Lordship, pleased to see this is a letter dated 2/2021. Address was to the Commissioner GST Central Guwahati. When I took inspection, we didn't find any such representation. Thereafter, this Honorable Court directed my learned friend to file an affidavit. Then they file an affidavit.
Let Mr. Kayal submit.
Yes, sir, they file an affidavit bringing on record such representation. Lordship, may come to page 275.
You are trying to say on facts they are not applicable.
No.
What is that you are trying to do?
I try to say that no application was filed to the proper authority at the relevant time.
So let them file the application then.
Subsequently they file. They agree on record. That is also important to look by your Lordship. Lordship, there are additional affidavit, page 275. 275. Additional affidavit, Lordship. Lordship, now.
Just one thing.
Yes. Page 275. Lordship, on top there is a rubber stamp is there. That is dated 2nd of June 2021. Now Lordship may come to page 173 again. 173, which I pointed out to your Lordship earlier.
This page 275 is the subsequent
development. If they file with their
before the proper authority.
Yes. No, not proper. That is also important, Lordship. The seal is of Silchar.
And this is before Guwahati.
address is to the Guwahati. And Lordship, may please to see page 173. There is no seal on that 173 road.
Yes.
There is no seal appeared in the page 173 road.
Yes.
Lordship, yesterday I also make inquiry from my office at Guwahati. Till date, they have not received any such representation till date.
So basically what you are trying to say in short is that according to you, according to the department, a proper application has not been filed.
Not been filed at the relevant.
At the relevant time.
Their contention is that they filed before the Silchar authority.
No, in that case, can we not dispose of these cases by directing them to file a proper representation?
No, Lordship, there is a time limitation is there. Because they have to file their application by 30th of September each year. Although this judgment was under stay, and Honorable Supreme Court on 22nd of...
Anyway, then some detailed hearing has to
Yes,
go.
Lord.
I am admitting and posting it for hearing. You heard...
But one submission, but in similar, all similar...
It's all right,
many
Ms.
cases.
Gope, we are fixing it for hearing. Item number 31.
34, Lord.
34.
Heard MS ML Gope, learned counsel for the petitioner. Stop. Also heard Mr. S.A. Kyle, learned. You're appearing as?
Standing counsel, GST.
Standing counsel, GST department. Stop. Case, prima facie case for hearing is made out by the petitioner. Stop. Admit. List, no formal notice as parties are represented. List on and date. After 1 week.
16, yes, other matters.
For hearing. Do you want this back, the judgment?
No.
I think you...
It is already annexed with the writ petition also.
You can always give it on the next week, otherwise it might get lost.
My lord, there is an interim in this.
Interim, if any, shall continue till then.
My-
None appears for the petitioner when the matter is called. Stop. List after 3 weeks on a date to be fixed by the registry. Item.
My please, your lordship, 438 application, my lord.
In this case, CD
Case
call for
diary?
my lord, case not received, my case
Not
diary not
received.
received. Okay.
My lord,
Can it be
today,
AB.
yes, my lord, AB, my lord, can it be on 38th of April?
my lord,
All
kindly
right,
see the, my
it
lord,
has not come. Await case diary list on.
my lord, kindly,
30.
for a moment, my lord, kindly the petition FIR, my lord,
30?
sanction is not applicable, my lord.
April.
My lord, yeah, sanction is not applicable, my lord,
2024.
according to FIR, my lord.
Next.
Sanction is not applicable according to FIR, my lord.
41, my lord, we have received the case diary, my lord, today. But my lord, I require 1 day accommodation, my lord, because
He's
there are
already
some...
on interim.
Yes, he's
I'm
on
only
interim, my lord.
in 2016 matter already appeared before that.
When do you want?
Any Monday, my
List on Monday, interim to continue.
Monday,
Final on 24.
All right. 24th, your interim to continue.
and legalized law.
Obliged.
May it please, my lord.
Yes.
My lord, this is a case for compensation, my lord. Otherwise, it is a,
Compensation for land.
my lord, a bungalow was occupied by Assam Special Police Force in Golaghat region. The thing is that
Instruction is awaited, my lord.
Instruction.
From this deputy
2018 matter, Ms.
One
Barman.
instruction has come from respondent number 5, my lord, that it doesn't reflect regarding payment of anything, my lord. So I need to take instruction from the district authorities, my lord.
my lord, otherwise
Because
the
they
dues
are-
are admitted, my lord.
Because they are, that bungalow was rented for use for themselves, my lord, by the authority of district commissioner. So under that circumstance, I need to take instruction from them.
MS M. Burman, learned counsel, learned government advocate, appearing on behalf of respondent.
1 to 5.
Respondent numbers 1 to 5 submits that though she has received some instruction, but the same is not conclusive, and the same
File
is
the affidavit,
the
not
same is
sufficient
not
to file the-
sufficient for
file the
filing.
affidavit.
The same is not sufficient for filing the return. Stop. Accordingly, she seeks accommodation Stop.
3 weeks, my lord.
List the matter after 3 weeks to enable MS M. Borman, Learned Counsel for the state respondent, to file necessary return in the matter positively. Stop.
I'll try.
Okay. Please file it. It's a 18 matter.
Deeply obliged.
Obliged.
Lordship, item number 41, I have some problem 24. Man. Can it be on 25, 26? If anything.
25?
Deeply obliged.
25, 5. 25, 4. Item.
May I please, your Lordship? Lordship, matter may be adjourned for the day, Lordship. My senior counsel is not available.
Item 45. Yes, government.
Instruction not received, Lordship. We had
20
already
matter.
Lordship,
It's very sad that 20
Lordship,
matters and
Lordship,
till
20
now
matters.
nothing has come.
Lordship, we already been communicated on my lord 28/7/2020.
That is on 20.
2020.
But after 20, nothing has happened now.
No,
it's
my lord,
2024.
till date, my lord, the matter have not been listed. Today is the second time they have.
All right. Mr. J. Hendik, Learned Counsel for the Land and Revenue Registration Department of the Government of Assam. Correct?
Lordship, I am for a state. My learned friend is for a revenue department.
You are appearing for the state this time. In 2020, you had appeared for the
Lordship,
for the
on
revenue.
that time only.
Mr. J. Hendik, Learned Government Advocate, Assam, appears on behalf of respondent number.
Respondent number 3, 4,
3, 4,
5, 6,
3, 4, 6,
6, 7.
6, 7, and MS PK Bormon, PR Bormon, Mohanta, Learned. Now you are appearing as Standing Counsel Revenue, Learned Standing Counsel Revenue, and yes, Mr.
Lordship, I am appearing for respondent of crime.
And R5. It appears that affidavits have not yet been filed despite the matter pertains to 2020. Stop. The Learned Counsel appearing for the respondent assures that the necessary returns shall be filed within a period of
3 weeks, Lordship.
3 weeks from today. Stop. Let the same be filed. As a last chance, the prayer is allowed. List after 3 weeks on a date to be fixed by the registry. Get it filed.
Lordship.
Contempt.
My lord, petitioner is supposed to get, my lord.
Respondent 1 to 3 were supposed to file affidavit. Has the affidavit been filed?
2 filed.
Not filed.
2.
2 filed. R2 has filed. What about 1 and 3?
My lord, not filed.
You are appearing for 1 and 3?
Lordship, I'm appearing for respondent number 3.
Respondent number?
3.
Have you filed your affidavit?
Lordship, I appear for respondent number 2.
What about your
1 and 2,
affidavit?
Lordship.
The 2 has filed. What about 1 and 3?
Lordship, 2 has filed, Lordship, and wakalat number for 1 has filed. Lordship.
Item 46. Now, are you filing your affidavit or we decide the contempt?
Lordship, Lordship can give me some time.
Just make that request.
Lordship, I came in a hurry, Lordship.
No problem. Mr.
M. Bhagavati.
M. Bhagavati, Learned Counsel for the respondent number 1.
Lordship.
161 and MS. Naam to loi lo ba so and so for respondent number 3 seeks 2 weeks time for filing necessary affidavit in opposition in the matter. Prayer is not opposed. List the matter after 3 weeks on a date to be fixed by the registrar. In the meantime, the petitioner is at liberty to file a reply against the affidavit in opposition filed by respondent number 2. Yes, you wanted to say something?
Lordship, in fact, number 1, Gyanendra Dev Tripathi, Lordship,
he has done.
is not in the department
in the mean, that I am not saying anything, but you do the needful. If he has already been retired, then you might have to bring
He's in another department.
He has been transferred, so you might have to implead the new incumbent. I'm not saying anything, but that will be for your
It's for him to decide.
benefit, because otherwise the order will not be able to be complied. So you bring him on record. I'm giving 3 weeks. You do whatever is required.
Much of it.
Petitioner is not there, but on the last occasion, 21, petitioner was supposed to obtain instruction if the order has been complied. Are you there?
Colleague is there, my lord, but
All right.
the person no
None
longer in the
appears for the petitioner when the matter is called. List this matter after 2 weeks on a date to be fixed by the registry.
May I please, Lordship?
Yes.
Yes, Lordship. Lordship, in this matter, service has been completed, Lordship.
No one has appeared.
Lordship, on 3/3/23, respondent number 127, they have filed their wakalatnama, Lordship.
227. 227 or 127?
127, Lordship.
Huh?
127.
Do you want to file reply?
Lordship, they have filed only wakalatnama, Lordship.
No, an affidavit is filed by respondent number 227 on 22nd 11/21. Have you filed your reply?
Lordship, we have not.
You're not
filed,
aware?
Lordship. No, Lordship. I'm not aware of this. Lordship.
How come?
Lordship, we want to file reply, Lordship.
Your name?
Miss PP Das, Lordship.
MS?
PP Das.
PP Das?
PP Das, on behalf of Mr. PP.
Learned counsel for the petitioner seeks 2 weeks time to file necessary reply to the affidavit filed by respondent number 227.
Yes.
Stop. Prayer allowed. List after 2 weeks on a date to be fixed by the registry.
Obliged.
Who's for the petitioner?
King.
Some correction is sought. What is this IA for? Have you filed the IA?
No. In fact, man, this matter has possibly become infractuous. Would be infractuous by 29th of May. There was a prohibitory
But
order.
today there is no
Yeah,
one.
that's why.
So,
Maybe after some time.
None appears for the applicant. When do you want it, Mr.
Anytime, my lord.
List.
If it come in the first week of June, my lord, I talked with him also. It will become infractuous.
So shall I post it next week or after a week?
After 3 weeks, my lord.
After 3 weeks. List this matter after 3 weeks on a date to be fixed by the registry. Mr. B. Chakraborty, learned counsel for respondent number 6.
Lordship, as per last office note dated 10/4/2024, Lordship. Yeah, I have to file one substitution petition because respondent number 11 expired, Lordship. No, Lordship, but there is an order, Lordship, kindly see on 13/10/2023.
Yeah.
And there is no requirement for filing substitution petition because legal heirs of respondent number 11 are there, already there, Lordship. There is an already order 13/10.
Or they are already on record?
Yes, yes.
All right.
So let the matter come up for admission, otherwise service completed.
All right. It appears that it appears from the office note that service is already completed. List this matter for admission.
Yes. First week of May, possibly.
List this matter for admission on a date to be fixed by the registry in the first week of
May.
Obliged. এইকেইটা ওইটো দুটা ঠিক এইটো কোনটো মাত্ৰ Something was supposed to be filed here, if I am not wrong.
State respondent
Mr.
said that
Beach.
they want to file an affidavit.
If they are not filing, I am closing it. Where
Yes,
are
Your
they?
Lordship.
Where is your opponent?
That, they have been taken.
Ask your junior to Call him, Mr. B. Chaudhary.
But they have not served any copy. Your Lordship, they.
Which matter? Item 60. Oh, there is a request for VC in item 61.
Mr. R.B. Fukan. But your Lordship, they have not served any affidavit to us, so it seems they are not.
No,
ready.
but you see, without his presence, I cannot do anything. Otherwise, I will adjourn the matter. Is this the last matter?
They're calling.
What was that affidavit that was supposed to be filed about that scheme that is in operation?
Yes, but however, your Lordship, we are satisfied, your Lordship, by the status report of the ministry.
Date was given.
Date was there, as well as the NABARD report which we attended.
If I am not wrong, I had asked also for written submission.
Yes, we will be submitting. Only thing we are waiting if they bring something additional in the.
Very well, very well.
Otherwise,
you
I
can hand it over to,
by Monday morning. I will give it.
You see, in that case, you will have to email it to me.
Yes, I will.
Because this code will not be available.
Yes. I'll give a soft copy as well.
Let's see what happens today.
Yeah. Otherwise, the affidavit has admitted also. The 3 districts were allotted.
Am I? Am I audible, Your Lordships?
Mr. Fukan, this court cannot see you. The screen is off this side. I can only hear you. Yes, you are audible.
Okay.
Mr. Chaudhary is not present in court.
Yeah, and I believe he had to file.
It's not inconvenient. This court will again sit at 2 o'clock.
Right.
Okay.
You get hold of him and be here at 2 then.
At 2.
Grateful. We'll be here too.
Otherwise, any information about Mr. Chaudhary?
He has just sent an SMS. He has not picked up the phone.
What
saying
does it
that
say?
he is on legs in another court.
All right,
and he is in
at
the
2. Mr. Fukan, would it be comfortable for you to join at 2?
Yes, I am available for whatever assistance is required. I am available at 2.
Chaudhary is not in court right now. He's on legs in another court.
I'll be here. I'll be here.
No.
Grateful.
Lordship, I apologize. In the first step, I was.
No, that's all right. You are supposed to file something.
Lordship, we have filed it today. That is not on record, but I have given a copy, Lordship.
Have you served a copy to the other side?
Yes,
so I can close the hearing?
Yes, Lordship can close it.
But this has not come on record. Mr. Chaudhary, anything you...
We have
so I can close it now?
Yes, Lordship.
All right. Mr. B. Chaudhary, Lieutenant Council Agriculture Department has submitted that an additional affidavit has been filed today, so and so date. Stop. Hearing concluded. Let registry place the said additional affidavit on record and judgment reserved.
May I just...
Written submissions, this court will not be here, but please give it to my court master. She will thereafter email it.
Yes, I'll give soft copy as well as hard
soft copy and hard copy both.
Lordship, in the affidavit, in the later part, I have given whatever submission by written argument that was made, that I incorporated in the affidavit.
Right. Mr.
With the
Chaudhary,
Lordship's
if you
permission,
want to submit something on writing, you can also do it by Monday. If in case you want. Yes, Mr. Fukan?
I'm sorry to bother your Lordships. Only one small issue is that in the affidavit which has been served to us, we have nothing much primary to say. If at all is there something, all of us seeking a permission in that in the written submission, we'll bring it on record. Yes, that's all I'm seeking. I'm grateful for that.
But kindly serve a copy on the other side as well.
Yes, we'll do that.
Do the exercise by Monday itself, not later. Than
Monday itself. By Monday, your Lordships will get. Extremely grateful. Obliged.
I have a small prayer in the matter, Malad. Lordship is, this is although the matter is part of Malad, the respondent number 3, in WPC number 6343 of 2018, the respondent number 3, he is the complainant, Malad, the Commissioner and Secretary, Department of Food and Civil Supplies. But for the records, I have seen that no notice has been served on him.
Notice has not been served?
No, Malad. There is an office
Why
report.
this was not pointed out, Mr. Das? You said there was urgency and for hearing on the last occasion. That is how this matter was heard in part.
My humble submission is, Lordship is in the session of is hearing the matter. Let it continue. The petitioner is submitting.
Then we will issue notice. If notice is not served on some.
I prefer just 2-3 days accommodation. I may be given one opportunity on next week, on Tuesday.
Yes, Mr. Mahanta, Dr. Sharaf.
Let them come in and
I think it will not look appropriate. Though, of course, we've heard Dr. Sharaf at length. But since notice is yet to be issued.
My junior today secretary up, my lord. Regarding my lord, office note, my lord, there is no note that my lord notice was sent, but whether it is served or not, there is no, my lord. That is not completed. Tomorrow, my lord.
Which respondent?
For respondent number 3.
He is the complainant state of Assam, my lord.
In WPC 6343 of 2018.
R3. And Mr. Nath, you are appearing for R3?
I am appearing.
So then, what is to be done?
Let it be part of my Lordship has started the hearing. Let it be hard. I need just one opportunity.
No, my lord, I'll make my submission, my lord. Regarding preliminary objection, regarding maintainability, my lord, already matter has been decided by this honorable court, my lord, Honorable Justice Manish Chaudhary's judgment, and that is also, my lord, affirmed by the division bench, my lord. That in that stage, it is, my lord, it is not maintainable, and High Court has no jurisdiction to pass this order, my lord. So that point has to be satisfied first, my lord. Because your lord,
Mr. Mahanta, if I recollect, today was fixed for your reply.
My lord, I am ready, my lord.
Yes. But now, because of the submissions of Mr.
Earlier also the matter was heard, the judgment was reserved.
Anyway, we will give some time because there is no report also of the registry.
The judgment was also reserved earlier.
R3 has been.
That's it, I am not there.
I'm not. We will keep it in part heard. We will accommodate you for a week or 2 weeks.
1 week will do.
1 week, and we'll post it after a week. The only thing is, this code will not be available here for the next 2 weeks. So, if you want it in the second week, we can have a VC. Otherwise, after I return, that will be in the first week of May.
No, it can be VC, not because after all.
I agree, my lord. Because already now today he can submit also, my lord. Should I?
23rd April?
My lord.
Dr. Sharaf, 23rd April?
Should I submit?
23rd April. Yes, Mr. Mohanta?
Should I submit my written argument before you write down?
A written argument is there. Yes,
my lord. Along with all my lord judgment which I relied.
Very well, you can give it.
My lord, only
And his argument, his file, today I have received, my lord, and that's why
No, that's correct. I have only given the judgments, whatever are there.
So, or if you, Mr. Monto, you don't want to supplement anything, no? This is your final written argument.
This is my final report.
And Dr. Saraf, are you submitting today anything?
I am submitting today. The only thing was judgment, my lord, of the apex court, which was there, where they say that 26(1) the petition should not be maintained, but there the jurisdiction question was not raised. That I made mention in the written submission.
Dr. Saraf, heard Dr. Saraf, Saraf, senior advocate assisted by so-and-so. Also heard Mr. T.J. Mohanto, senior advocate assisted by so-and-so, learned senior advocate, and Mr. D. Nath, learned senior government advocate for the state respondents. Stop. Mr. Nath seeks 1 week time to obtain instruction from respondent number 3 in the matter. In the meantime, arguments have been concluded by Dr. Saraf. Stop. Mr. T.J. Mahanta shall give the reply argument on the next date.
My lord.
Correct? Next date. Stop. List the matter again on 23rd of April.
My lord.
23/4/2024 for further hearing.
My lord, about the second case, there are two cases are there. WBC 6342.
Yes.
This is about the imposition of the penalty of rupees 5 lakhs.
This first one is 6342.
6343.
6342 or 6343?
6343.
Item 51 is 6342.
My lord.
That is the case in which all these written arguments have been filed, correct?
No, actually 6343 is the main case, my lord.
6343 your lordship heard.
6343 to main. Yes, 6343 is the main case.
My lord. And 6242
yes
is about the imposition of
penalty
of 5 lakhs. Now here the issue is very short, my lord. My lord, I was asked to furnish the documents by
this
the
is not connected.
Same connected.
Same transaction of the same matter, my lord.
Okay.
Because he is not giving reply in proper time, that's why fine was imposed, my lord. That's the case. Against that fine order, he has come before the Honorable Court.
Yes. Well, the Director General asked me to furnish the informations, and the informations were very voluminous. So we part submitted it. We asked for time, for extension of time. The time was granted. Always the time was granted. Thereafter, on the last time, the Director General again sought for further clarifications. In the meantime, my lord, the Competition Commission issued a so-called notice to us. We submitted the reply saying that, my lord, these are the all extension orders are there. And on the last occasion, the Director General has sought for further clarifications. And the same has also been furnished. Before the passing of the order, all informations were furnished. In spite of that, the Commission has imposed rupees 5 lakhs as penalty for not furnishing information. Now, Section 43 of the Act, which provides, lays down, my lord, that the penalty, it says that if the failure is for reasonable cause, without reasonable cause.
646. Penalty, which section?
Section 43, my lord.
Section 43.
My lord.
Yes.
Lordship find in the Act.
Act on
in the written submission, yeah.
Competition Act.
Well, I've given the written submission there, I quoted, my lord.
Yes. Yes, please.
My lord, it says, if the person fails to comply without reasonable cause with the direction given by so-and-so and so-and-so, such person shall be punishable with a fine which may extend to rupees 1 lakh for each day, during which such failure continues, subject to the maximum of rupees 1 crore or so-and-so. Now, my lord, you'll also find that here it says fails to comply with. My lord, if any person fails to comply, now the tribunal, the Competition Law Tribunal, my lord, in earlier judgment, my lord, has said that belated compliance and fail to comply are two different concepts, and a penalty is only impossible if somebody fails to comply. Belated compliance will not come within the purview of Section 43 of the Act.
Yes.
Now, I complied with everything. The extension orders were there. So till when the extension orders were there, and after that the Director General asked for further clarifications. And in the meantime, the so-called notice was issued. And before the order was passed, we submitted before the commission that we have already supplied whatever information we furnished. In spite of that, the 5 lakh rupees penalty has been imposed. In the written submission, if your lordship looks into it,
Written submission to be
6342.
Yes.
Where the order starts at page 154.
Page 154.
My lord. And the relevant part you will also find at page 166. This is Competition Commission Tribunal, my lord.
150?
166.
Yes.
At the bottom below the
Yes,
five lines.
highlighted, yes.
My lord. By referring to the earlier order of the tribunal has observed that a finding on the question of fact gives rise to question of law when there is no evidence to support it or its purpose. When the finding is one of fact, the fact that is itself be an inference from other basic facts which will not alter the character. One of the fact in paragraph 18 there is a clear-cut finding given to the fact that impugned order of CCI is indefeasible because of non-consideration of the relevant materials. The tribunal then went to consider the scope of the term reasonable, relying on the stout judicial dictionary as well as the words and phrases. In paragraph 23, the tribunal observed that the word reasonable signifies an accurate accordance with reason. After discussing the reasonable cause, it criticized the CCI for having dealt with the implication of the term in a cryptical manner. In paragraph 28, the tribunal observed the CCI fails to distinguish the conceptual difference between the failure to comply and belated compliance. In the former case, it is non-compliance, and in the latter case, it is belated compliance. In a given case, when the compliance is to be done within a particular time and is not done, there is a failure. But when the time is extended...
Belated compliance is not a failure.
My lord. When the time is extended, my lord, then it cannot be said that there was a failure.
Failure is only when there is absolute non-compliance.
My lord. So in my case, when the it was absolutely the time was extended, and thereafter the further clarifications were sought for, and that clarifications were also provided, and before the commission passed the order, my lord, it was informed that all the informations have been furnished. Then there was no case of the imposition of the penalty, because penalty is a quasi-criminal proceedings, and when somebody, my lord, penalty is imposed, then it must be shown that there was a mens rea, there was intention, guilty intention in not providing information. When somebody is providing the information, then only symbolic 5 lakhs imposition of the penalty, that puts a stigma on the company that the penalty has been imposed for not providing information. Otherwise, for 5 lakhs rupees, the company would not have come before your lordship, troubling your lordship. So, my lord, I have given the judgments of the Supreme Court as well as our High Court also, Division Bench of the High Court, my lord.
Yes.
Wherein it was said, my lord.
Our High Court is...
that is Brijlal
Rajalal.
Banik, my lord.
Banik.
Banik. And it starts with, my lord, page
137.
137, 11 part at page 146.
Yeah. What is the state of MP's case?
My lord?
There is one state of MP case versus Ram Swarup.
State of MP?
Serial number 8 in your compilation.
My lord, yes. But that is the meaning of reasonable.
Meaning of reasonable?
Reasonable cause. What is the meaning of reasonable cause?
And Kingfisher Airlines?
That I placed before lordship.
That is belated.
Belated. Hindustan Steel is the penalty.
Then Hindustan Steel is on penalty. And Brajalal Banik?
Brajalal Banik is on the issue of penalty, as well as that when somebody time is given, then he becomes a defaulter only after that date.
After the time expires.
My lord.
And the Supreme Court decision, Manohar Lal?
Manohar Lal, my lord, it is the provisions of the statute must be interpreted in this way, because the reasonable cause earlier was not there.
Must be interpreted?
my lord, that intention of the legislature must be gathered from the, because reasonable cause, earlier the word was not there.
From the context of the
My
statute.
lord. Now, subsequently, it was my lord, inserted in the section. So, the insertion of the reasonable cause in the section has to be given a meaning that what was the intention of the legislature in incorporating the provision.
And Karnataka State Financial Corporation?
99, my lord, that is Karnataka, I placed before, Lordship, my lord.
That is on?
That is Karnataka interpretation.
Interpretation.
My
Both
lord.
Manohar Lal and Karnataka are
My lord,
interpretation.
my lord.
All right.
And New India assures also
Yes.
on the interpretation.
All right. And sale?
Sale is at page 25, page, my lord, I placed it, my lord, it says, my lord, that the Director General was supposed to submit the report within 45 days. Now, he initiated the proceeding after 1 year. Now, if the Director General initiated the proceeding 1 year, then, my lord, the reasonable cause is there or difficulties are there, then our submission is there that both should be treated in the same part. If he initiates the proceeding after 1 year, whereas the Supreme Court has said that within 45 days he must complete it, and on the other
Here
hand,
a time frame is given.
well, the Supreme Court has let down the 45 days.
In the Competition Act?
No, my lord. There is no time limit.
There is no
There is no time limit, my lord. That is up to the commission. And in fact, my lord, in this case also, my lord, I'm probably, my lord, my learned friend has to point it out before this, my lord, before the argument starts. There is the appellate provision. He has not availed the appellate provision. Now directly come to the court, my lord. What are the...
So your attack on maintainability is on that?
No. Earlier is different. In this case, my lord, the order which was salient before this honorable, but it is the appellable order.
The
It's the appellable order.
Alternative remedy is not being exhausted.
Yes, my lord, that is not exhausted, my lord. That is, he is not availed that, my lord.
I will not.
It is the appellable order.
Absolutely, my lord. I have not availed because the order is actually without jurisdiction. If the order is without jurisdiction, my lord, then the question of availing remedy does not arise. And in the earlier case, I have given that judgments in the first case, including the Godrej Sarali, the recent judgment, where the question of law is there, my lord, whether...
What is the appeal provision?
53, my lord. 53B, my lord.
53 capital B.
My lord.
You will also kindly see page 78, the sale judgment, my lord.
Yes.
Page 78, the relevant part.
The Director General in terms of Regulation 20
is expected to submit his report within reasonable time. No inquiry by the Commission can proceed any further in the absence of a report by the Director General in terms of 26(2) of the Act. The report by Director General should be submitted within the time as directed by the Commission, but in all cases not later than 45 days from the date of the passing of the order and so and so. So this was the apex court order, judgment. Now, he initiated the proceeding after 1 year. Now, if the Commission
78
can condone or my lord that the whatever delay was there, even initiation of proceeding after 1 year, then in our case, after extension 8 days, how the Commission can say that there was no reasonable cause? If the Director General has a reasonable cause for initiation of proceeding after 1 year, where the Supreme Court has said 45 days, he must submit the report, then both must be treated as par. One cannot say that in your case, there was no reasonable cause, but in the case of the Director General, there was a reasonable cause.
All right.
So, my lord, I don't have anything better. Only thing is that, my lord, penalty proceedings, which you lost aware, when the order is absolutely without jurisdiction and the question of law is involved. The question of law is that what is the reasonable cause and whether reasonable cause can be construed, what is the intention behind the insertion of reasonable cause. The reasonable cause words were not there earlier in section 43. That were
when has it been brought in?
Well, that I mentioned in the written submission, my lord.
Okay.
My lord, from 25/9/2009.
2009.
9.
And you are this assessment.
This period is, my lord, the 2000. The order is.
Sorry, the penalty order is
much after. My lord, this is 2017 or 18.
So therefore, this 2009 amendment will apply.
Yes.
Okay.
So, my lord, this further there is nothing for me to submit. I've given the judgment.
Mr. Mohanty, you want to give the reply in this
case? My lord, in this case, my lord, regarding this one, earlier, because whatever he has submitted, my lord, that is not 26(1), my lord, that is 26(2), my lord. Your lordship kindly see 45 days. I will come to that like earlier case, my lord. Here in this case, my only submission is that, my lord, there is the appellate provision, my lord, he has not availed the appellate.
53.
53 on your lordship kindly see 53, my lord, 53A, appellate tribunal.
I admit it.
The National Company Law Appellate Tribunal constituted under Section 410 of the Competition Act 2013 shall and on from the commencement of the so and so the hearing and disposal of appeal against any direction issued or discretion made on order passed by the Commission under Section 2(6) of the Section 26, Section 27, Section 28, Section 31, Section 32, Section 33, Section 34, 38, Section 39, and Section 43. So if that order was passed under Section 43, so it is my lord within the appellate authority jurisdiction. So he has not availed that things directly came before this honorable court. So that is my only submission.
Now, according to you, this is without jurisdiction. That is why, that is your reply to the argument.
One thing more, 2018 the petition was filed. 2018 the petition was filed.
2018. 18.
Thereafter, it remained pending. Thereafter, the rule was issued in the case, and the apex court judgment is also there. That when the case is pending and the rule
is issued,
and a petition is admitted, then after expiry of 6 years, my lord, the petition should not be dismissed.
You have
so that I am not given because I heard it. I will give the judgment.
So that question is already well dealt by that Mizoram judgment by the apex court in 22. My lord, I have annexed, my lord. Your lordship will get everything there.
Whirlpool judgment is also there. Whirlpool.
I have also annexed.
These are self-restrained at the end of the day, right?
My lord,
now the exceptions are without jurisdiction, natural justice.
No, my lord. In the stage of 26(1), whether court can interfere or not.
No, that is
the facts of the matter, my lord.
That is case number 1.
My lord, here I am submitting what happened in this case. Just like
your submission is now on 6342, right?
53 is referring to
yes,
43 now.
6442, my lord. All right. I will reserve my 6440. Yes. Correct. Here only argument then, my lord, there is a appellate. My lord, that's fine.
Absolutely. I have taken note of that. Your argument in 6342 is that they have not availed the
alternative
remedy, which is Section 53 appeal. Right?
Yes.
Reply to that is that the order of penalty is without jurisdiction.
My lord.
Correct, Officer?
My lord, that's my argument. Yeah, I will reserve my argument for that, man. 46.
That we have already passed the order. So here, as far as 6342 is concerned,
there is nothing for me to nothing.
So I think arguments both sides is completed.
Completed, my lord. Yes.
We are putting it together, but
my lord, yes.
Only I give the judgment. Only I will give the copy of the judgment that where the
whatever is there, you give it.
My lord,
one copy only. Otherwise, I given the judgments below.
All right.
Deeply.
Lordship is sitting at Kohima bench,
no,